Hello everyone, welcome back to the channel. I am Miss Sini and I'm an intern in LEXIS and Company. I'm back with yet another video and today's topic will be Contract of Guarantee. So let's get started. Black Law Dictionary defines the term guarantee as an assurance that a legal contract will be duly enforced. A contract of guarantee is mentioned in the Indian Contract Act 1872 and includes three parties in which one of the party acts as the suretor in case of the defaulting party fails to fulfill the obligation. Contracts of guarantee are mostly required in cases when the party requires a loan, employment or goods. The guarantor in such case assures the creditor that the person in need may be trusted and in case of the default, he shall undertake the responsibility to pay. Thus, we may say that contract of guarantee is an invisible security given to the creditor. So first let us understand what is a contract of guarantee. According to section 126 of Indian Contract Act, contract of guarantee means a contract to perform the promises made or discharge the liability of third person in case of his failure to discharge such liability. As per the section, the contract of guarantee has three parties. First is the suretor. A suretor is a person giving the guarantee in the contract. A person who takes responsibility to pay a sum of money, perform any duty for another person in case that the person fails to perform such work. Second is the principal debtor. A principal debtor is the person for whom the guarantee is given in contract of guarantee. Third is the creditor. The person to whom the guarantee is given is known as the creditor. Also, we can understand that a contract of guarantee is a secondary contract that emerges from a primary contract between the creditor and the principal debtor. So, an example to this is that Ankita advances a loan of Rs 70,000 to Pallavi. Shrishti, who is the boss of Pallavi, promises that in case Pallavi fails to repay the loan, then she will repay the same. In this case, the contract of guarantee, Ankita is the creditor, Pallavi is the principal debtor and Shrishti is the suretor. So first let us understand what are the essentials of the contract of guarantee. First is there must be an agreement of all the three parties. All the three parties, that is the principal debtor, the creditor and the suretor, must agree to make such a contract with each other. Second is consideration. According to section 127 of the Act, anything is done or any promise made for the benefit of the principal debtor is sufficient consideration to the suretor for giving the guarantee. The consideration must be a fresh consideration given by the creditor and not a past consideration. Third is liability. In the contract of guarantee, the liability of the suretor is secondary. This means that since the primary contract was between the creditor and the principal debtor, the liability to fulfill the terms of the contract lies primarily with the principal debtor. It is only on the default of the principal debtor that the surety is liable to repay. Fourth is presupposes the existence of the debt. The main function of the contract of guarantee is to secure the payment of the debt taken by the principal debtor. If no such debt exists, then there is no left for the suretor to secure. Hence, in case when the debt is time-barred or void, no liability of the suretor arises. Fifth is must contain all the essentials of the valid contract. Since a contract of guarantee is a type of contract, all the essentials of the valid contract will apply in contract of guarantee as well. Thus, all the essential requirements for a valid contract such as free consent, valid consideration, offer and acceptance, intention to create a legal relationship, etc. are required to be fulfilled. Sixth is no concealment of facts. The creditor should disclose to the suretor the facts that are likely to affect the suretor's liability. The guarantee obtained by concealment of such facts is invalid. The last essential is no misrepresentation. The guarantee should not be obtained by misrepresenting the facts to the suretor, but the facts that are likely to affect the extent of suretor's responsibility must be truly represented. Now let us see what are the kinds of guarantee. Contract of guarantee may be classified into two types: specific contract and continuing contract. First, let us understand specific contract. A specific contract is for the single debt and at any specified transaction. It comes to an end when such debt has been paid. Example to it is that Sneha is a bookseller who supplies a set of books to Prashant. Under the contract that if Prashant does not pay for the book, then his friend Kunal would make the payment. This is a contract of specific guarantee and Kunal's liability would come to an end the moment the price of the book is paid to. Second is continuing contract. According to section 129, a continuing contract is a type of guarantee which applies to the series of transactions. The suretor's liability in this case would continue till all the transactions are completed or till the guarantor revokes the guarantee as to the future transaction. So the example of this is that on Mahesh's recommendation, Sneha, a wealthy landlord, employs Prashant as the estate manager. It is the duty of Prashant to collect the rent every month from the tenant of Sneha and remit the same to Sneha before the 15th of each month. Mahesh guaranteed this agreement and promises to make good any default made by Prashant. This is the contract of continuing guarantee. Now let us see revocation of guarantee. So far as the guarantee given for the existing debt is concerned, it cannot be revoked, as once an offer is accepted, it becomes final. However, a continuing guarantee can be revoked for future transactions. In that case, the suretor shall be liable for those transactions which have already taken place. A contract of guarantee can be revoked in the following two ways. First is by giving notice according to section 130 of the Contract Act, and second is by the death of the suretor that is mentioned in section 131 of the Contract Act. Now, what is the period of limitation? The period of limitation for enforcing a guarantee is 3 years from the date of which the letter of guarantee was executed. The difference between contract of indemnity and the contract of guarantee, as these two are special types of contract, but there are many differences between the two. Some frequently asked questions on contract of guarantee. First is, write the circumstances when the contract of guarantee is invalid. Circumstances when the contract of guarantee is invalid are some of the follows. That is, first, when the guarantee is obtained by misinterpreting or misrepresenting of fact. Second is when the creditor obtains guarantee without disclosure of material facts or with the intention of committing fraud. Second question, can a contract of guarantee be written or oral? Yes, a contract of guarantee may either be oral or written. It may be express or implied from the conduct of the party. Third question, what are the rights of the suretor? After making any payment or discharging the liability of the principal debtor, the suretor gets various rights. These rights are under three heads. First is right against principal debtor, second is right against creditor, and third is right against co-suretors. The fourth question is, what is the difference between contract of indemnity and contract of guarantee? In the contract of guarantee, there are three parties to the contract, namely suretor, principal debtor, and creditor. Whereas in case of indemnity, there are only two parties to the contract, promisor and promisee. This is the most basic difference between both the contracts. So now let us get into the conclusion. The contract of guarantee is a specified contract for which the Indian Contract Act laid some rules. As we discussed, the basic function of the contract of guarantee is to protect the creditor from the loss and ensure him the confidence that the contract will be enforced by the promise of the suretor. Every contract of guarantee has three parties and exists two types of guarantee, that is specified guarantee and continuing guarantee. The types of guarantee depends upon the situation and the terms of the contract. In this video, I have tried to provide a comprehensive look at the important provisions of the contract of guarantee. The significance of the contract of guarantee stems from the fact that it plays a very important economic role in the commercial world. So I hope that you liked my video and understood the concept well. Please hit the like button and I'll meet you soon in the next video. Thank you.